about this. I think we have a slight technical delay. We live stream. I don't know if you're aware of that, so that you can watch it in a remote location, and you can watch it on YouTube, the FMS YouTube channel tomorrow as well. It will be uploaded. So, a formal good morning, ladies and gentlemen. Thank you very much for joining us at this briefing on the rule of law on this cold Johannesburg morning. Welcome to members of the media. I'm Jane Boccoleone, and I look after media relations for the Free Market Foundation. We have a very important topic this morning, the rule of law, and I'm very pleased to see such a good turnout, because this can be a very dry and difficult subject to appreciate, to understand what it really means and the impact it has on our daily lives. We're absolutely thrilled to have a very distinguished guest with us this morning. Rex van Schalkwyk is a former judge of the Supreme Court of South Africa, and he's also the chairman of the Free Market Foundation's Rule of Law Board of Advisors. This board seeks to influence the nature and content of laws and regulations, as well as promote the understanding and appreciation of what the rule of law actually means. Rex has asked for a very short introduction, so I'm just going to say that he's the author of 3 books. The first is a novel. The second is One Miracle Is Not Enough, which published in 1998. It deals with the failures that were then already evident in our new democracy. The third, published in 2009, is Panic for Democracy, and it deals with the evident failures for many years of the democracy of the United States. So just to let you know, on your chair, there is, for those who may not have it, please look, there is a paper that deals with the imperatives of the rule of law, which Rex will take us through. But please take this away and read through it. And with that, I'll invite Rex to join me on the platform, and thank you very much.
Thank you, Jane. As Jane has said, the topic of this morning's talk is the rule of law. But that really is a bit misleading, because the purpose of the rule of law is not law as such. As with much law, the purpose is quite often hidden and is not immediately apparent to the casual observer. The real purpose of the rule of law is the liberty of the individual. And if one thinks deeply about it, it becomes evident why this must be so. Because all law must be designed to serve the utility of the public for whose benefit the law is enacted, or for whose benefit the law has been adopted by way of the common law. Now, there are 2 broad streams that have been pursued over the years in developing the jurisprudential politics of the search, the ongoing search, I would say, for the liberty of the individual. The first emerged really from the ideas and the philosophies of the Enlightenment, which led ultimately to the French Revolution, and which led in turn to the American War of Independence, and then to the establishment of what was really the first properly formulated constitutional state. And as Thomas Jefferson said at the time, and he was probably one of the first of the true libertarians, although I say that guardedly, because he was also a slave owner of note. But one should bear in mind that hypocrisy of this kind has always been an inherent part of politics and politicians in general, and one can't really hold that too seriously against Thomas Jefferson as he was then in the late 18th century, because as a matter of fact, things had not changed to the extent to which they have changed by now. The fact is that Jefferson believed in a small state. He and his colleagues, the so-called founding fathers, believed in the establishment of a state whose purpose was to serve individual liberty. So that was the purpose of the American Constitution and the purpose of the establishment of that state. Tragically, that purpose has been very, very significantly abandoned and betrayed during the course of the years, and more significantly in the last 20 years or more. Even the Supreme Court of America, which is appointed by the President, and whose purpose it is to act as guardian of the American Constitution, has abandoned many of the significant principles of the Constitution upon what I think is this rather spurious basis that the Constitution was drafted more than 200 years ago, and therefore many of its provisions are no longer relevant to the present day and the present circumstances. Now, that is the one branch of the attempt that has been made thus far in order to achieve proper individual liberty. The other, which I think is even more significant, is the development of the rule of law. Now, the rule of law was not an enactment. It never came about because somebody sat down and wrote down the rule of law. It never came about because somebody thought that it was important to write a treatise on what was considered to be the rule of law, although Professor Dicey did so somewhat later and after the development of many of the principles of the rule of law. But the rule of law came about almost spontaneously. It came about in order to meet a human need. And the human need that had to be met was the need for individual liberty. Now, there have been many attempts to describe or to define the rule of law, and the Free Market Foundation Rule of Law web page even describes how difficult and how almost impossibly complex it is to try and find an appropriate definition for the rule of law. I think sometimes that we lawyers tend to exaggerate the complexity of the issues that we deal with. And this is perhaps one such issue. The rule of law is not nearly as complex as the lawyers tend to make it. But then lawyers are known for their verbosity and, regrettably, also for the fact that they tend to engage in a great deal of jargon. So it doesn't surprise me that the various attempts that have been made by lawyers to describe the rule of law have not generally met with success. But I want to suggest a very simple phrase which captures the essence of the rule of law, not a definition. It's not a definition because it doesn't contain all the essential ingredients, but it does capture the essential nature of what the rule of law is. And what I would suggest is a phrase comprising 3 words: the accountable ruler. Now, you may say, why the word ruler? It's an anachronism. Well, I'm pleased you've asked the question, because ruler is something that we've not yet dispensed with. We've just recently emerged from 8 years of a ruler, a despotic ruler in South Africa. But more than that, we can see the emergence of a ruler in the person of Donald Trump in the United States, that constitutional democracy. So we certainly haven't yet, as a society in general, emerged from the era of rulers. And in any event, there are apart from that, there are three reasons why I deliberately choose the word ruler. The first is that rulers are still with us. The second is that, as a matter of fact, a ruler is somebody who actually conducts the affairs of state. Now, it doesn't matter terribly much whether that ruler is called a ruler or is called a government or constitutional democracy or what have you. The effect always is the same. The effect always is to control the lives of others, to make laws that have the effect of controlling the lives of others. And that is why it is my contention that there really isn't any good law. The only law that serves a useful purpose is the law of utility, the law that serves the general good of the public. And that law should be kept to an absolute minimum in order to interfere as little as possible with the rights of the individual. So once again, it will be seen that the rights of the individual are paramount. The other reason why the word ruler is important here is an historical reason. If one goes back into the history of British or English jurisprudence, one will find that in general the source of the rule of law is said to be with the Magna Carta of 1215. Now, the Magna Carta was an interesting document because it was a document which King John, or his representative, he wasn't even himself present when the document was signed, that he at least consented to the 63 clauses of the Magna Carta, of which only 3 are relevant today. But King John himself had his back against the wall. He'd just fought an unsuccessful campaign against the French. He was himself had recently been excommunicated by the Pope, and he had, as all warmongering monarchs and rulers had at the time, a shortage of money. He was unable to fund his various expensive enterprises. And it was for this reason that he did it under, in a sense of coercion, as it were. But the important thing about the Magna Carta is that it contained, apart from the included in the 64 clauses, it contained 3 clauses which have survived to this day. And the first of those clauses was the right of the free man. Now, this was limited to the free men and not to everybody, and one would assume that a free man in this case is distinguished from the serfs. But the free man would incorporate the nobility and the clergy. The church, of course, was terribly important at the time. So the clauses that guaranteed individual rights in the Magna Carta were those that related to free men, and the first of those was that every free man was entitled to a fair trial, and the trial was to be conducted before a jury, an impartial jury. The second important principle was that no individual, including even the king, is above the law. Now one would say, well, how does that guarantee the right of the individual? Well, for a very obvious reason. Because as soon as somebody is above the law, and one can assume that that somebody is most likely to be the ruler or the king, then you have the beginning and probably already a very well advanced form of despotism. And the whole principle behind the Magna Carta was that the individual rights were to be placed at the forefront of every aspect of it. The third requirement was a form of representative governance. Now, I use this expression advisedly because it wasn't governance in the modern sense of the word, but what the nobility and the clergy insisted upon was that there was to be no representation without taxation. And of course, it was the nobility in particular who had this preoccupation with the issue of taxation. And King John, of course, required the taxes in order to fight his wars. So those were the 3 principles. And that was the beginning of the development of the ideas that eventually led to the concept of the rule of law. But it would be a mistake to suppose that the Magna Carta was in fact the very origin of the rule of law. It started a long time before then. And in fact, many of the issues that are today commonly regarded as aspects of the rule of law were regarded by Roman and Roman Dutch jurisprudential scholars as an innate part of the law itself. And they conceived the idea of the law of nature. The law of nature, they said, maybe somewhat fancifully, was the law that is divine and is written in the stars. So what they really meant by that is that it's not man-made. The law of nature is made in the instincts of the community, and arises out of the instincts of the community in the way in which people instinctively feel the difference between right and wrong. They feel instinctively the difference between evil and good. And these are not things that need to be written down or decreed. These are things that every sentient human being will understand. So that is the basis of the rule of law. And one can go back even further than that to the rule of King Hammurabi of Babylon, the city-state of Babylon, in the year 1750 BC. Now, King Hammurabi had a vision, and his vision entailed an encounter with 2 gods by name Anu and Bel. And according to this vision, Anu and Bel instructed King Hammurabi to make just laws for the benefit of the weak and to take action against the wicked. to destroy the wicked, in fact. That was the instruction that he said was given to him. And as a result of the instruction, Hammurabi set about the task of writing his law code, his famous law code, which, so far as legal scholars are aware, is probably the first written example of a law code. This law code was inscribed on various pillars of stone, and these pillars of stone were displayed in the central square of the city-state of Babylon. Now, in doing what he did, he complied with an instruction that had been given to him to make laws of a certain kind. He was at liberty to make the kind of laws that he wanted, but he specifically said that he was told to make laws of this particular kind. And it was in compliance with that order, with that instruction that was given to him by the two gods, that the law code of Hammurabi came about. Now that really is a classical example of the nature of the rule of law, because above the ruler himself stands another authority. And the other authority that stood in the case of King Hammurabi were the two kings, Anu and Bel. And he acknowledged their authority over himself. That is what he set out to do, was to obey the command that had been given to him by the two gods. Now, it will be understood then that in every well-ordered state, the ruler is subordinate to the law. And this is because in a properly functioning democracy, the ruler of the government is subordinate to the people. So the subordination comes about, first of all, towards the law, because the law is the authority above the ruler, and ultimately the authority above the law itself is the liberty of the individual. That is the purpose that has to be served. And we must always remind ourselves of the fundamental purpose of the law, which is to serve the liberty of the individual. Now, this is really a background to the issue that is confronting South Africa in particular, but perhaps the world in general at the present moment. And what we have to bear in mind is that a lot of the legislation, the man-made law that comes about, is designed in one form or another to centralize power, to centralize authority with the ruler, whatever form that ruler may take, and in consequence to detract from the liberty of an individual or a group of individuals or a whole nation of individuals. The manner in which this kind of tyranny can be described is by legislation that oppressively undermines a particular industry or activity. Now, this has happened in South Africa as a result of the developments over the past 20 years by legislation which is overtly designed to control certain industries. We see in particular two examples of this kind of legislation, and these are examples of the kind of legislation that have been analysed by our researcher, by our very industrious researcher. So the one category of this sort of form of legislation is legislation which is overtly oppressive of the mining industry, which is now practically destroyed. Now that's an interesting point, because one is inclined to say, well, you know, the mining industry is a matter of interest to the miners. It's a matter of interest to the plutocrats of the Johannesburg Stock Exchange, and who's really concerned about what's happened or what may happen to Anglo Gold or to Harmony Gold or to any of the other big mining companies. What's happened to Anglo American once the premier company listed on the Johannesburg Stock Exchange? Well, it's no longer a South African company, effectively. It's now run from abroad. Anglo Gold has already given a clear indication that they want to withdraw, and others will do the same. So one may say, well, that is to the disadvantage of the shareholders, but so what? I mean, you know, that may be the kind of response that one may have. But it's not just that. The mining industry in South Africa has been systematically destroyed over a period of time, and the result is that some 500,000 jobs have been lost. Those people who've lost their jobs probably have not been able to replace those jobs elsewhere. They're trained to do a particular kind of work, admittedly a very arduous job of work. It's certainly something that none of us would ever want to undertake. But as a matter of fact, when you have no choice, and when you need to put bread on the table and feed your children and educate your children, then perhaps you'd be very grateful for a job of that kind. The other way in which the government has in the past undermined various industries is by way of rhetoric, which is frequently designed to inflame hostility against, in particular, the banking and financial services industries. Now, in this, by way of example, we see cases of talk, rhetoric, which frequently emanates from members of the ANC, most frequently from the EFF, who have over and over again proclaimed the need to nationalize banks. And if they're not going to be nationalized banks, then we must at least have a state bank. Well, considering the abysmal way in which the South African state-owned enterprises have been run and actually almost destroyed, I need hardly mention the examples. It seems rather arrogant of these people to think that they can effectively establish a commercial enterprise like a bank and run it successfully. Also, of course, we hear the phrase white monopoly capital. Now, this is an intriguing phrase because it came into existence apparently as a result of some think tank which thought that this was a good way of deflecting attention from the numerous failures of the governing party, but also because of the timing. It came into vogue within the ranks of the ANC at a time when the ANC was particularly under threat, partly because of poor election results in the municipal election, and partly because the media had taken up the refrain to say, well, this government is on the wrong track. It is doing the wrong things. The country is being looted. It's being systematically looted and being impoverished, all to the disadvantage of the individual members of our society. So white monopoly capital came about as the bogeyman. But now, why white monopoly capital? I mean, everybody would agree that that monopoly capital is undesirable, and various advanced systems of law have legislation to prevent monopolies from forming. You've got it in the United States, you have it in Britain, you've got it in Europe. As far as I know, it's even to be found in the Asian countries. And it makes perfect sense, because once you have a pernicious monopoly, well, the monopoly can do what it likes. Effectively, it controls the market, controls prices. And it is not subject to the economic law, the imperatives of demand and supply. But in this case, we're not confronted by the bogeyman of monopoly capital. We're confronted by a political party, by a particular kind of monopoly capital, and it's white monopoly capital. So there's a racial element to this thing, and it is undeniably there. And it serves no purpose at all for the ANC to say, well, it is really just a particular brand of monopoly capital which is more prevalent than others, and that's why we've singled it out. Well, I doubt very much that all the monopoly capital in the country is attributable to the whites, on the one hand, and in any event, even if it were, why is it necessary to put a racial appellation to this phrase? Why not simply say we must rid ourselves of monopoly capital? So all of this indicates that there's a hostility, that there's an underlying hostility that emanates from the ANC government, and that this hostility is manifested in some of its legislation, as I will point out in due course. Now, an analysis of the laws that have been passed have demonstrated two broad trends that confirm that the industries, particularly the mining industry, and on the one hand, and then the banking and financial industry on the other, have been targeted. There's legislation on mining, and the crippling BEE requirements of mining. And let's not forget that BEE requirements effectively mean that the existing shareholders must share their shareholding, their existing shareholding, with others, the Johnny-come-latelys. And effectively, nowadays, at no cost, no contribution is made. Once upon a time, they went through the motions of making a contribution, but not any longer. And the new mining charter apparently envisages not 26% holding by previously disadvantaged people, but 30% holding. But the most pernicious aspect of all is that once empowered, according to the ANC, no, not always empowered. So the mining companies dish out effectively 30% or 26% of their equity to previously disadvantaged individuals, and the previously disadvantaged individual can, within a certain period of time, sell out that entire shareholding, as has happened. It happened, as a matter of fact, with Harmony Gold, when they had an employment partner by the name of Mzee Khumalo, nowadays a billionaire, one of the other Johnny-come-lately billionaires, who was empowered by Harmony Gold in consequence of this legislation, and within a short while he sold all his shares for many, many hundreds of millions of rands. Well, all of a sudden, Harmony Gold found that it was exposed because it was no longer compliant. And not being compliant, the government said, well, you must top up again. Well, you can imagine where this would lead. If the company has to keep topping up every time these shares are sold, eventually it will have no shares left in its original shareholding. It will all be gone. It'll have to buy shares from its existing shareholders in order to dish them out. It's a sure route to insolvency and bankruptcy. But none of this is perceived by the ANC government. All that it's concerned with is the immediate result. But the important thing to realize is that it is not only the mining companies, not only Harmony Gold or Anglo Gold or the others that are adversely affected by legislation of this kind, but it is everybody who's connected, even remotely connected to the industry. And ultimately, it is the entire community, because all of these industries are vital for the economic well-being of the country. And the more we undermine the economic well-being of the country, which has been systematically done over the last 8 years and longer, the more everybody will pay the price. We pay the price in inflation, we pay the price in the diminishing value of the rand, which immediately translates into increased costs of fuel and increased costs of transport and so on. So, let it not be forgotten that legislation which appears to target a particular industry actually has a far, far wider effect and far wider implications than appears at first sight. Now, there are two broad principles of law that we have discovered in our research, and this, in particular I'm referring to Gary Moore's research, that emerge from this issue, the legislation of this kind. And the first broad principle is that where Parliament makes provision for a regulatory supervision of an activity, now this is called regulation. So Parliament says, this is the act, but so-and-so, the Director General or the Minister or somebody duly appointed by the Minister will have the power to regulate certain aspects in order to ensure that the bill is given effect to. Now, the principle of the law is that where this is done, it is permissible to do it, for the legislature to do it, but it must only be done in circumstances where the situation in which regulation will be permissible are clearly defined, where it's clearly understood the extent of the authority of the regulatory authority, and for what purpose those regulations may be enacted. Otherwise, of course, one is confronted by lawmaking by decree. And that is really the problem that we confront today in South Africa, because more and more regulation regulation of the kind that is open-ended is giving rise to a situation of legislation by decree, where the minister says something and that becomes the law. That is, of course, intolerable to the rule of law. So the other situation, the one is where you have regulation, the other situation is where the lawmaker, Parliament, delegates an authority to a particular individual and says, well, you've been delegated to do certain things. The minister is delegated to to say certain things about certain aspects of a particular industry, the mining industry or the financial industry, as the case may be. Well, that kind of legislation is simply illegitimate, because it is a fundamental principle of the rule of law that the only law-making authority that has legitimacy is the properly elected Parliament. Now, Parliament for national purposes, provincial councils for provincial purposes, municipal councils for municipal purposes, those are all at their level law-making bodies, and they're entitled to make laws within their field of competence. But they're certainly not entitled to say, well, we as a provincial council will authorize our member of the executive council in charge of education to do certain things in regard to education, and to take his own decisions as to which schools may be opened, which schools must be closed, when they must be opened, when they must be closed, and so on. That effectively is giving the MEC in charge of education the power to make law, and that is simply incompetent. Now, there are striking examples of violations of these principles, which I've just now enunciated, which emerge from the research that has been undertaken by Gary Moore. Excuse me. Gary Moore did an analysis of 23 laws, of which he found that 22 were not compliant with the rule of law in one way or another. Now, I've not discussed this with Gary Moore, and I'm fairly sure that what he will have done, because lawyer that he is, he will know more or less which acts of Parliament are most likely to be in violation of the rule of law and which are not. So I dare say that he selected the ones most likely to be in violation, because that was his purpose, to find violations. So I'm not saying that the 22 out of 23 would represent a sample of all the legislation. I don't say that at all. But it still is a significant set, and if one looks at the detail of each of these laws, in order to determine how precisely they violate the rule of law, one can see the extent to which the legislature simply has paid no attention to the rule of law whatsoever. Now, if I were to start with what I think is perhaps the most egregious in mining, there's the amendment which has been proposed and already adopted by both houses of Parliament, but apparently still awaiting signature by the President, or at least that was the most recent information that I've had on this matter. It's the amendment of the Mineral and Petroleum Resources Development Act of 2002. And in terms of this amendment, a strategic mineral, that's the term of art that is used in the law, a strategic mineral may be designated by the Minister. And a strategic mineral in the language of the Act is any mineral that the Minister may designate as strategic. Well, now just pause there for a moment. So, first of all, there's a strategic mineral, which is the subject matter of the amendment of the Act. And secondly, of course one would say, well now, what is a strategic mineral? That's a natural question. And the answer is, well, it's any mineral that the Minister may designate. Now, is that not a classical case of legislation by decree? What the Minister says is the law. Off with his head. What the Minister says is the law. You know, it's most extraordinary that two houses of Parliament, with their various legal advisers and the people who draft these bills, cannot have seen that that is an absolute violation of every fundamental principle of law, never mind the rule of law. It's just a fundamental violation. The strategic mineral is what the Minister says it is. But now, it has serious consequences, because once having designated a particular mineral as a strategic mineral, the next step is that beneficiation of that strategic mineral can only be undertaken by a commercial mining company as directed by the Minister. So now that gives him another dictatorial power. The Minister now can say, this is a strategic mineral. It wasn't yesterday, but it is now. And I'm going to tell you to what extent you must beneficiate this for the benefit of the community, but also I will determine price. So it effectively puts the private enterprise business of mining out of business. I cannot imagine how anybody, how any overseas visitor, investor, excuse me, could possibly hope, could possibly want to put himself into a situation of that kind. It is simply intolerable. And from any point of view, one must say to oneself, this is hostile legislation, hostile to the industry, hostile to the people working within the industry, hostile to everybody whose livelihood depends upon that industry. It is hostile to the individual. That's what it is. Now, the thing goes further. Any right to prospect for such mineral may not be encumbered or sold or hypothecated or anything else done with it. So if you've got a particular mining lease to exploit a particular mineral, and the minister has now declared that this mineral is a strategic mineral and it's destined for domestic beneficiation, no, you can't deal with it. You can't. You're now stuck. So not only does he put you in a position where immediately the asset is worth a lot less than it was before, but now he puts you in a position where you can't even sell it. So you can't think, frankly, of a more emphatic form of commercial imprisonment than that. The minister, moreover, has the right to determine the proportion of the mineral concerned that must be reserved for local beneficiation and determine the price thereof, as I've already said. And any person who wished to export a designated mineral or petroleum product may only be entitled to do so with the written consent of the minister. Well, the minister in all of these respects is a dictator. Let's not put too fine a point on it. The minister is a dictator. So this is a dictatorial piece of legislation. And the ultimate victims of this dictatorial legislation would be the individuals who are effectively who are affected by it, including, more particularly, and at the most vulnerable level, the workers. Because the more these businesses shut down, the fewer of them come into existence, the fewer job opportunities there are. And we all know about the dire state of unemployment in the country. Another example of the same kind of thing emerges from the Currency and Exchanges Act of 1933. Now, immediately it becomes apparent that this is not legislation that emanated from the present government. They were certainly not in power in 1933. But what is important is that this legislation is still on the statute book, even though it violates the rule of law in very fundamental ways. And not only is it still on the statute book, it has been applied. It was applied in the celebrated Shuttleworth case, of which I think everybody has taken note. And Shuttleworth went to the Supreme Court of Appeal with an appeal to the Constitutional Court with an appeal against the determination that was made by the minister, and he failed. So unfortunately the court also failed properly to take account of the rule of law. But this is what the Act says in substance. The President may make regulations regarding any matter with a bearing on currency. So he can make regulations on any matter that has a bearing, as remote as can be, but of very wide power. Banking or exchanges, and the regulations may have retrospective effect. Well, one of the fundamental principles every first-year law student will have learned, that you cannot have law that retrospectively makes unlawful actions that were lawful at the time when they were done. The very essence of the rule of law is that law must be clear, as Hammurabi did. He made it clear. He said, these are the laws. You can see them. Read my laws. My code is there for all to see. They must be clear. They must be discernible. They must be comprehensible. And they must be in prospect. They must relate to issues on the future and must not relate to issues of the past. So any act of the past cannot by any legitimate means be made unlawful in any way whatsoever. So this clearly, once again, is a fundamental violation of the rule of law. But it's still in the statute books, and as I say, it has already been applied in one celebrated case by the ANC government. Then we have, also on a financial level, the Financial Advisory and Intermediary Services Act, FAIS, of 2002, in terms of which the registrar is empowered to determine fit and proper requirements for each category of service provider. So fit and proper requirements are determined by the registrar. fit and proper is a requirement which one has to have in terms of the legislation in order to be able to practice a financial advisory service. If you're not deemed to be fit and proper, then you're not permitted to practice at all. You don't get a license, your license can be withdrawn. It also determines the fit and proper requirements for key individuals, representatives, and compliance officers. Ongoing education is the responsibility of the service provider. So the law makes a requirement that everybody must be fit and proper. Then it makes a requirement that there must be a system of ongoing education. It also makes a requirement that the provider himself, the person in charge of that particular enterprise, has a statutory duty to ensure that the employees under his control and within his organization, all of them comply with the requirement of being fit and proper individuals to do the job. And if he fails to do so, he can be deregistered. So deregistration is one of the consequences, and the ongoing obligation to do so ensures that presumably the provider will continue to provide this fairly onerous service upon pain of being deregistered. But if an employee within the industry happens to be deregistered, he cannot practice in any capacity whatsoever within the financial advisory service industry for a period of at least 12 months. So for 12 months this person is out of a job. And he can't go to a competitor and say, well, I've just been regarded as not fit and proper by company A, and would you please just look at my credentials and look at my years of service and interview me as you like and do tests such as you like. And if you're satisfied that I'm a suitable candidate, I'm very happy to join you tomorrow because I'm desperate for a job. No, it can't be done. It can't be done. He's debarred. He's debarred for a period of 12 months. Well, the effect of this draconian piece of legislation, recently introduced by the ANC, is that it has been calculated that 16,000 individuals who are mainly black entrepreneurs have been debarred or deregistered as a result of this legislation. Now, if one thinks about it for a moment, it becomes evident why the young black entrepreneur who wants to start off in this industry and perhaps has a BCom degree from university and has had 1 or 2 years of practical experience, wishes to make his way in the financial advisory services industry. And he starts off perhaps with his own small business, or perhaps he starts off as an employee. And he gets tested. And having been tested, for some reason or other, he fails. Now, let's not forget that the employer is not the person best suited to test his employees, because the employer has a subjective interest in the matter. The employer is himself involved in personal relationships with his employees. He has potentially a great conflict of interest. Let's take a simple example. A predatory employer who is attracted to the various young girls in his employ has his advances rebuffed by one such candidate, and at the next testing session this person is failed. Well, having been failed, that person is debarred from employment within the industry for a period of 12 months. Unfortunately, the Supreme Court of Appeal held this legislation to be perfectly in order, and also came to the conclusion that this legislation, that the person empowered to test the employee was best able to make this determination because he knew what he was about. Well, that's a very naive assessment of the situation. But let's not forget that the effect of the legislation is punitive. It is punitive upon those people who will find themselves out of a job as a result of the determination made by the employer. Now, this Financial Advisory and Intermediary Service Act of 2002 has been followed by an even greater menace. And this is this Financial Sector Regulation Act of 2017, last year. And no doubt some or many of you have heard of Twin Peaks. This is the Twin Peaks legislation. And it envisages what were called two centers of authority. The one is a prudential authority, which is the Reserve Bank, which will supervise the solvency of banks, especially of banks and insurance companies. Well, the Reserve Bank may be qualified to supervise the financial solvency and viability of banks, because banking is its business. But what about insurance companies? Insurance is an essentially different kind of business. But nevertheless, this is all lumped together now under that prudential authority. And then there's a market conduct authority, which is somewhat more sinister, which will direct excuse me, direct how financial services companies design their products, and it will be a supervisory authority with little or no knowledge of the detailed structures of the methods of the industry they are empowered to direct. Well, you can imagine, now, if you have a conduct authority which has authority to approve or disapprove a product within an industry as complex as the financial services industry, that you're unlikely to be able to do so with any competence unless you've had several years of experience in that very industry. Most unlikely that any of these bureaucrats who are appointed to this position will have that kind of competence. But what about a financial business which comes along with an innovative product? And I can think of a very specific example. Capitec Bank started off some 8 or 10 years ago with an idea and a sense of adventure, perhaps. And the idea was, well, we must provide banking to the less monetarily privileged. I don't want to call them the poor, because it's not necessarily poor, but people who have greater difficulty in raising finance. And Capitec started off with that idea. We will provide services to people who are unbanked, have been heretofore unbanked, and unbanked because the existing traditional bankers are too conservative to advance facilities, loans, overdrafts, and things of that sort to this particular category of people. Well, it's immediately apparent which category of people I would be talking of. It's talking about black people, essentially, and others previously disadvantaged, who hadn't had the advantage of a proper education, or whose parents hadn't had the advantage of a proper education, and who themselves are now, for the first time, beginning to make their way in the commercial world. And Capitec Bank's idea was, well, we will provide this service, and we're going to provide a great level of supervisory competence, and we will provide a sufficient degree of capital adequacy in our banks, and this is our idea. And with that idea, they set up their business. Now, I dare say that there would have been a number of skeptics at the time when Capitec Bank started its enterprise, who would have said to them, well, they are taking an enormous chance, because the prospect of various insolvencies, especially if the economy should start to turn down, which indeed it has done, is so great that one cannot possibly envisage a bright future for a bank of this kind, which operates particularly and specifically within this industry. Now, imagine that Capitec Bank had come to the regulatory authority, which was then in existence, assume that it had been in existence at the time, with this idea, with this business model. And they'd said to a bureaucrat, well, this is what we're going to do. This is going to be our capital adequacy requirement. This is how we're going to run the show. We're going to be very innovative. We're going to have personable individuals, and we won't have the formal foreboding atmosphere of a traditional bank. We will have a more welcoming atmosphere, and so on. And the bureaucrat looks at this and says, but hang on a moment, how can you expect this to survive? You're going to bank the unbanked, the people who have no assets, who have no reserves. Well, what if things start to go wrong and your bank goes bust? I have the responsibility of ensuring that you're coming to market with a proper and a viable product. And because I have that responsibility, I'm going to refuse. I'm not going to permit you to do this. Well, that could very well have happened if such a conduct authority had been in existence at the time when Capitec was started. But we know the story of Capitec. It's been one of the most spectacularly successful vehicles on the Johannesburg Stock Exchange for the last nearly decade. It has been spectacularly, and is now vying as a competitor with some of the major banks. So there you are. Not only would many unbanked, millions of unbanked people have lost the opportunity of the banking experience, but this very viable enterprise and the people who rely upon it now for a living, the employees and the others, will also have missed an opportunity because of a regulatory authority. Now, what these various examples demonstrate is that this government has an obsession with control, and an obsession with control is always inimical to the rights of the individual, always. So when a government wants to take control of various industries, of various people, of various activities, you can be sure that the first victim in the process will be individual liberty. There are, however, just two other examples that I want to touch on very briefly, because they are also very egregious examples. And I don't want to belabor the point, but here are the two examples. The South African Schools Act of 1996, passed after the present government came into power. According to the South African Schools Act, and there are no criteria provided in the Act itself, it empowers the MEC, the member of the Executive Council, to close public schools, and also empowers the MEC to determine the grounds on which registration of an independent school may be granted or withdrawn. Once again, this is a man or woman with dictatorial powers. Upon what basis? You come along and you say, well, the school must be closed. I determine, I'm the MEC in charge of education, I determine that this school must be closed. What, Mr. MEC, is the basis? Well, please tell us, have we done something wrong? No, I've made the determination. I'm entitled, I'm empowered to do it. I'm not saying that the MEC is necessarily going to act with that level of arrogance. But what I am saying is that the law empowers him to do so. The law actually gives him the power to do so. And if he were an arrogant individual, he may well be prepared to say, well, I don't have to give reasons, I don't have to tell you anything. So, again, individuals suffer as a result of these excessive powers, and as a result of the ANC's determination to go ahead, headlong with its legislative program, regardless of the consequences and heedless of the requirements of the rule of law. National Health Act of 2003. No person may conduct a health facility without a certificate of need. Now here we've got another phrase which needs definition. What is a certificate of need? Well, a certificate of need is whether this institution is required to do the job that it proposes to do in the area that it proposes to do it in, and for the benefit of the community that it will apparently be serving. So those are the requirements. Now, a certificate may be withdrawn by the Director General if the establishment or worker in the establishment obstructs the state in its obligation to provide access to health care. Now, that is an extraordinary provision, because the health provider can have its license, its right to conduct its business, withdrawn if it or one of its employees obstructs the state in its obligation, the state's obligation, to provide health care to a broad base of the community. Well, what would obstruction of that objective be? Suppose for a moment that someone sets up a business in some prominent suburb in Hyde Park in Johannesburg as a healthcare provider, and establishes a private hospital in that area with permission. And along comes the MEC in charge of health, and he says, well, hang on a moment, you've been here now for 4 or 5 years, but you're not doing anything to promote adequate and equitable access to health care. People who come here are all either already on a very generous medical aid scheme, or alternatively they are well financially endowed and they can afford to pay the tens of thousands that it costs to be here. What about all the other people who can't afford it? And we, the government, have an obligation to provide health care. There's a constitutional obligation upon us to do so. And your enterprise, the way in which you're conducting your enterprise, is obstructing us, the government, in the achievement of that objective. And so therefore we are ordering the closure of this enterprise. Well, it sounds like an extreme example, but it is theoretically possible. Theoretically possible in terms of this legislation. I don't want to belabor the question of these acts, because there are many of them, and if anybody wishes to look more closely, it's all on the web page, and it's all very comprehensively set out. But the examples demonstrate that the ANC in government has no concern for understanding of the rule of law, and that they seem to be intent upon transferring their constitutional obligations to do certain things to the private sector, upon pain of closure, upon pain of punishment. So that's another clever device which the ANC in government has employed. It says, well, we've got certain constitutional obligations, so-called second-generation rights, which found their way into the Constitution, to provide housing, to provide health care, to provide succor, and so on. And we're now going to impose that obligation upon those who are best able to do it in the private sector. And if those who are best able to do it in the private sector don't do what we tell them to do, we'll close them down. Well, that is a mentality that has pervaded the lawmaking process of the present government for some time now, but in particular over the last number of years. And now one says, well, what are the consequences? Well, the consequences are dire. The first consequence, as I've indicated, is a consequence for individual liberty. And individual liberty is not some fanciful slogan that emerged from the French Revolution or before. Individual liberty is a fundamental principle of individual life, of being a human being, of being alive, that people should be free. And it has been stated over and over again. What Martin Luther King was about was individual liberty. He said he wants his people to be free. And always, wherever people have been oppressed, it is freedom that they've required more than anything else. So individual liberty is the first victim of this kind of abuse. But then, of course, it's also collective well-being. If one thinks of the 8 years of rule of the Zuma presidency, it becomes evident, and it's becoming more evident with the passage of time, now that he's gone and now that proper analysis is beginning to be done, that as a matter of fact his presidency actually hollowed out the state in terms of its resources. The resources that the state now has at its disposal to do all the various things that the state has undertaken to do, or that it wishes to undertake to do, are now seriously undermined by the fact that the resources are simply not there anymore. You've got what is said to be 5 million taxpayers providing social security for 17 million people. Well, it's an impossible task. And in any event, it's not 5 million taxpayers. The people who genuinely pay proper significant taxes, I'm talking about income tax and not VAT, probably number fewer than 500,000 or 600,000 of the entire population. So there is an impossible task which is being made more impossible still by all of the legislation of the kind that I've described here. And as the state becomes hollowed out, as the private sector becomes hollowed out, as the mining companies and financial companies are being hollowed out and destroyed in the process, so there will be fewer and fewer opportunities to work our way out of the situation. Some prominent economists have already predicted that it will take decades to undo the harm that was done by the Guptas in close alliance with President Jacob Zuma. And Zuma undoubtedly facilitated what the Guptas did. The Guptas arrived in, they were menial workers. They were apparently selling spare computer parts from the boot of their car at Bruma Lake. And they left the country 8 or 10 years later as billionaires. Billionaires. Now, Gigabe said that the reason why he accelerated their process of acquiring South African citizenship was because of their significant contribution to the economy of the country. The only contribution that they made to the economy of the country was to loot it. They have significantly and systematically looted the economy of the country, and we will all, every one of us, will pay the price. And the price will be paid for the next several decades into the generations as yet unborn. So this is how significant the maintenance of the rule of law is. It's significant to the maintenance of a stable and a civilized society. It's significant to the maintenance of civilized standards throughout the society. And most important of all, it is significant for the well-being of the entire community. Without it, the community cannot prosper, it cannot survive with well-being. And it is a great tragedy that this situation has been allowed to happen, and it has happened to a very large extent because the rule of law has been systematically undermined by the present government. Thank you.
Thank you very much. I'm sure we have a lot of questions. Yes, questions, please. Yes.
Questions.
And if you would state who you are and what your question is, please. I think, Anthony, you begin.
Yeah, my name is Anthony Still, and in my private capacity. The one thing you said in the beginning about where this sort of, what sits above the ruler, and you said it's a sort of instinctive law. Now, if you are a religious man, you'd say that's God. What's the alternative to that hypothesis? And that's the one question. The other question is, do you think Ramaphosa's, what do you think his instincts about all this state control, centralization, do you think he has an instinct about that?
Well, your second question is the easier one to answer. I'm prepared to give Ramaphosa the benefit of the doubt, which I think we should do at this stage. Although I have to say that I don't know why he's latched so enthusiastically onto the idea, also a violation of the rule of law, by the way, of expropriation without compensation. And not only has he done so opportunistically, I thought initially, well, he's in a pickle because he's come into power in a fraught situation, and it will remain fraught for many years. And he has to try and unscramble this mess that has been created. And it's very easy for those who created the mess to say, well, now look at this man. He's making an even bigger hash of what we've got here. So he's in a very difficult position. And I thought initially that he would mouth a few platitudes about the need for creating a more egalitarian property owning community in South Africa. But in fact, he has repeated his position, and I think he's repeated it more and more stridently as he goes along. So I now have real concern. I now have real concern for his sincerity. That doesn't mean that he's not in a pickle, because he certainly is. And the pickle that he is in is the one that I've described. And it's also been suggested that there are various groups of politicians within the ANC who are now beginning to form alliances, almost anti-Ramaphosa alliances, not necessarily pro-Zuma alliances, but anti-Ramaphosa for opportunistic reasons or for whatever reason. So he is vulnerable. Whether he can succeed or not, I don't know. I have my doubts. I think partly he's not going to be able to succeed because of the intractable problems that he's got, but partly I think he's not going to succeed because I don't know that he's entirely sincere. And that's perhaps the more significant observation that I can make. On the source of the rule of law, the law of nature, well, written in the stars and is divine, well, there's already a word there that harks back to religious conviction. Whether one would say, I mean, I don't think it is opportune for me to express a view on a religious topic, and I would prefer not to do so. I have my personal views on these matters, but I don't think that it is opportune for me to do that now here. But it may well be that there is a source which, as the writers of old said, is divine. Maybe. Could be. Any other questions?
Petrus Potgieter from Yemi, Africa. My question is about extraterritoriality. You've not really referred to it, but I would like to ask whether you see that as part of the rule of law, territoriality, and it is something which concerns me, not so much with regard to South Africa, but with regard to other states in the world, that is confusing and possibly dangerous.
Sorry, could you just be a little clearer? What do you mean by extraterritoriality?
So do you see the territoriality of the application of law as an important, or as part of the rule of law principle at all? And do you have any view about developments in that regard in the world? So my impression is that there's more and more extraterritorial legislation, mainly from other states, perhaps not from South Africa.
Yes, well, extraterritorial legislation is fairly easily dealt with, and of course the principal culprit in all of this is the United States. I suspect that you have the United States in mind as well, because that's what they're doing. That's what they do with the sanctions that have recently been imposed against Iran, and they set about to bring everybody onto their side, either by way of coercion, and it's legislative coercion, which is to say, well, we've got laws in our country which says that if you don't comply with our sanctions against any country or against any source that we may deem undesirable, then you are in violation of our domestic laws, But we will apply that against you. I think the extent of the application can only be a domestic application. By way of example, so let's suppose that Mercedes-Benz has a very lucrative contract with Iran for the export of big limousines, because the Iranians have now taken to big limousines. And it's so lucrative that Mercedes-Benz chooses not to comply with the American sanctions. They're entitled to do so by way of German law. And the extraterritoriality of the legislation that you're describing doesn't apply to the application thereof, at least not in an extraterritorial sense, but only domestically. So what the Americans can do, and what they probably would do in the example that I've cited, is to say, well, Mercedes-Benz, we are going to prohibit the importation and the dealing in Mercedes-Benz cars and parts in the United States, which they're entitled to do. But the question really relates not to the rule of law, but to international law. It's an international law issue, and international law has its parameters. It deals with, in fact, a rather different set of circumstances. But it's an interesting question that you ask, because it does demonstrate the extent to which states, and in particular the United States, have overreached themselves in what I consider to be the creation of an empire. The United States seems to be hell-bent upon taking control of the affairs of the world. And more evidence of that is to be seen. They're fighting wars all over the place. Their military is spread all around the world. And they are determined to spread United States hegemony throughout the globe. They want to enforce their will against the Russians and against the Chinese, and they've already done so against the Japanese. And the Australians and the New Zealanders have been brought to heel. And although Trump offended Trudeau the other day with a personal comment, an insulting comment, the Canadians also are by and large on side. So it's a troubling development, but it's not really a rule of law issue, though.
Hugh Lane, just in my personal capacity, I'm with you entirely on the dangers of rule by executive decree. I was just wondering, though, to what extent public officials who have been given dictatorial powers to regulate, where they are perhaps constrained by the principle of rationality in the decisions that they make. Your comments, please.
Well, it's an interesting question. But the rationality of the decision only comes about upon a review of the decision. So that involves a court process, doesn't it? And not every man can engage in a court process against an instrument of state. Because as we know perfectly well from the Zuma experience, there's no shortage of money to conduct court cases, innumerable court cases that run indefinitely. And in fact, the more indefinitely they run, the better Zuma feels about it. So, but I digress. It's not just Zuma. You're talking about maybe a member of executive council, whoever. But you'd be taking on essentially a branch of government. And if you're an individual, let's say you're a relatively small individual, just starting out with relatively limited capital resources, well, rationality theoretically will come into it. Will certainly come into it. But it's a theory only, because you've got to get into court. And you've got to get someone to argue that case. And we know that court cases cost tens of thousands and hundreds of thousands and millions of rand. So I'm afraid there's a practical difficulty there. Yeah.
Any further questions, ladies and gentlemen? Okay. Otherwise, may I thank you, Rex, for an illuminating presentation and thought-provoking. And may I suggest that if you want to take this further, you look at the Rule of Law website and the website and other information on the Free Market Foundation's website. The next briefing is on the 17th of July. It's on the anti-tobacco legislation, which is actually pro-individual freedom. It's not against the tobacco smoking per se, or as people seem to think that we are against. Yes, we're not. It's pro-individual freedom, which is rather like Rex was talking about this morning. So thank you very much. There are some refreshments at the back. Please join us.